What took place during 2013, we started with these pretty modest beginnings. Mike Amos and Elaine Block and a group, I don't want to try to name all the names because I can't remember them, but there was a core group of attorney mediators who are well known throughout the state of Texas as the leaders of this specialty in Texas. And they got very concerned about the possibility of Rule 169 going into effect without ever having had any comments or any input from the attorney mediators. So we were able to organize a really stellar group of attorney mediators that are well known by all the lawyers and all the judges in Texas. So their opinions were very important to the Supreme Court and to various legal organizations. We were able to meet with Chief Justice Hecht and the staff of the Supreme Court, including the rule's attorney, and generate a great deal of comment about the rule from attorney mediators, from people who use mediation services, that is lawyers and some judges that commented on it. And we were able to get the views of those who use mediation in front of the court, where it hadn't been, and the court hadn't had the benefit of this input prior to the beginning of 2013. Then, and we were able to get the rule turned around or modified so that courts could still order cases to mediation. They could take advantage of using mediation in appropriate circumstances. And we also spent a lot of time meeting with various legal organizations such as the Board of Trial Advocates, the Texas Trial Lawyers Association, the Defense Council, various judges, and meeting with members of the Supreme Court in addition to Justice Hecht to explain our position and that of the Texas Attorney-Mediators Coalition. At the same time, the legislature convened in 2013, and we were able to get the concerns of the Attorney-Mediators Coalition in front of key members of the legislature who are strong lawyers and accustomed to, and some of whom were mediators themselves and use mediation services in their own practices. And we were able to get them involved in commenting on how mediation needed to be taken advantage of. We discovered there were approximately 39 bills that were introduced in the 2013 session of the legislature that affected mediation in one way or another. So the TAMC became the spokesman for the professional attorney mediators in Texas. And we testified on a number of these bills. We met with members of the legislature who were sponsoring this legislation. We testified on their bills. We assisted them and these legislators and their staffs in commenting and helping them make their legislation better. And so as a result of that, we became the recognized voice of the attorney mediators in Texas with the legislature and with the courts. So here we are in 2014, and when we get asked, when members of the legislature, judges, legal associations, chambers of commerce, trade associations, et cetera, ask about what do the mediators think, they call the Texas Attorney-Mediators Coalition. In addition to meeting and being involved in the legislature and with the courts, we've embarked on a vigorous campaign to meet with key trade and professional associations and to educate them about the values of mediation and how important it is to the public. And those groups include, and we've developed relationships with key groups such as the Texas Retailers Association, the Texas Restaurant Association, the Texas Association of Business, the Home Builders Association, and others. And so we've developed relationships with them to inform them about the importance and the uses of mediation and how it is valuable to the civil justice system. We maintain ongoing relationships with the trial lawyers, the defense bar, and other judges groups, and most recently, Chief Justice Hecht has named Justice Deborah Lehrman as the Supreme Court's liaison to the Attorney-Mediators and to the Texas Attorney-Mediators Coalition. So we've come from the beginning of 2013 scrambling around, not knowing what might happen next, to being recognized as the voice of attorney mediators when the legislature is considering legislation, when courts are considering rules, and when trade and professional associations are considering ways that they can assist their members. In addition to these building relationships and becoming the recognized voice of attorney mediators, both when the courts are considering things and the legislature, the National Center for State Courts has embarked on a research project to study the effect of what ultimately became Rule 169 on the use of mediation in Texas, and the TAMC was asked to have a seat at the table, was asked to provide a member of the advisory committee for this academic study that's being taken on by the National Center for State Courts, which is a research organization studying trends in state civil justice all over the country. So that's just further evidence of the place that the attorney mediators have been able to claim since we started less than 2 years ago. And you know, this is indicative of conversations that we had back in the 90s about the idea that, and it shows that if we don't look out for ourselves, nobody's going to look out for us. Having Rule 169 promulgated by the court with a blue ribbon panel of well-known lawyers and others, without ever asking the attorney mediators, yet having a rule that would have had a huge impact on the practice of mediation and the ability of the courts and the public to use mediation, just demonstrates that if we don't look out for our own interests, nobody's going to look out for our interests for us. And there could never be a more clear example of how important it is for the Texas Attorney-Mediators Coalition to exist and be active and express its views about the need and importance of mediation to policymakers as well as to the courts and to the public.